name's Joanne Peters, and I work at the law firm whose name is on that bright red poster behind my head. I'm a trial attorney. I've been practicing, I think I'm in my 16th year of practice, believe it or not. I always wanted to be a trial attorney since junior high. I love it. But I hope for your sake you never have to meet me or have to meet a litigation attorney, because if you do, that means you've been sued, and nobody likes to get sued. I mean, it's just not fun. I mean, it's fun for me, but I don't have to live it personally or emotionally. But if you do get sued, I thought it might be helpful for me to give you a little mnemonic to remember about what you ought to do the day you get the complaint in the mail or you receive the complaint by hand delivery from a lovely process server, like Dog the Bounty Hunter or something like that. I don't think he serves process, but if he did, that would be scary, wouldn't it? Well, here's the mnemonic I want to give you, and it's S.U.E.D. How appropriate, right? S-U-E-D. So let's start with S. See, I made a handy little letter S. S stands for Save Everything. If you've been sued, one of the things that will happen is the other side's going to ask you for documents or emails or text messages or Facebook posts, anything that might have to do with the subject of the litigation. That's why you need to keep everything. If you don't keep everything, in other words, if you don't save all of that stuff, and then later the other side asks you for it and you tell them, well, I threw it away when I got the complaint because I was angry, then you can get in trouble with the court. So save everything. The next letter, you saw me look down so I can make sure I could pick it up, is U. U. Understand that everything you say can and will be used against you in a court of law. Okay, that's part of the Miranda warning, which applies in criminal cases. We're not talking about a criminal case, but it's kind of true in our civil cases too. If you talk to someone and you tell them, yeah, I got sued, the truth of the matter is I really did do what they said. Hey, that person can come into court and testify that you said that. And then that's a problem for you in defending the litigation. Or should I say it's a problem for me in defending the litigation, because I'd be the attorney representing you, let's hope. So, understand anything you say can and will be used against you. E. Now this is one that people are generally shocked to find out. E stands for expect. Expect that it could take 6 months to 2 years for your case to get to trial. That's right, 6 months to 2 years. There's a lot of litigation, a lot of lawsuits, a lot of cases. So you're going to have to be patient. There are different things I can do and things I can file with the court to try to make it go away sooner. But that doesn't always work. Certainly you could always settle. But if you aren't and you're gung-ho and you're going to go to trial, expect 6 months to 2 years to get there. And the last letter I want to talk about is D. And this one is my favorite. Do hire an attorney. Isn't that clever? You should hire an attorney. Trying to go through the litigation process on your own can be a daunting task. I mean, face it, lawyers spend 3 years in law school studying the law, and then we spend many years practicing and many years practicing in court to know the ins, the outs, how to dot the I's and cross the T's. So really, you should hire an attorney. So that's my mnemonic for you, S.U.E.D. If you get sued, remember S-U-E-D and call me.